basically it's there should be a combination of duty and rights, like in many other fields of the international law. So a landlocked country has this right to reach the sea until this right do not interfere with the sovereignty of the traffic state. Then there is a section of 4 articles from Article 127 to Article 128 that is in regards to the custom duties, the taxes, because when you talk about transport, you enter in the economic field and enter in a field that is connected with the international tax law. It's important to guarantee to the landlocked states to have access to the sea and to the naval transport, but is also important to guarantee that the transport by this state, it will not be burdened by, let's say, not motivated duty or tax. Because of course, if we have to transport something from Hungary to be loaded on ships on the Black Sea or in the Adriatic Sea, let's say Adriatic Sea, that's more simple. Of course, it's not something directed to Slovenia, to Italy, to Croatia, but anyway, it has to cross this country, and the crossing can be the tax duty eventually imposed from the transit nation can be a real obstacle for the exercise of the right, and therefore the landlocked countries have to be guaranteed under this aspect. Last, there are of course several other articles. Many of them take care of, let's say, more practical aspect of the exercise of a right to have access to the sea. The last important article is the Article 131, the equal treatment in the marine ports. This is something that is not connected with the access to the sea, but is connected to actually with the exercise of the right of navigation, to use the sea as a way of transport. This article, I can read it. Ships flying the flag of the landlocked state shall enjoy treatment equal to that accorded to other foreign ships in the maritime ports. As you know, all the maritime country has agreements regards to the treatments of the ships. There is an international regulation for that. This article establishes that even the ships that travel under the flag of a landlocked country should be guaranteed the same equal treatment to all the other. This is also can be something unusual, because people think why a landlocked country should have a naval register. Naval register is the organization that organizes the travel of the seagoing vessels. Is the organization who take care of the security, of the quality of the of the crew and give actually the flag to the seagoing vessels, like for the airplanes. This another is aviation register, but they are basically they have the same function. This could be curious because a landlocked state who has no access to the sea, it shouldn't have a merchant marine, a transport marine fleet, or even any type of vessels. The reason why this state, and I'm speaking about San Marino, but I can speak also to Switzerland, organize a naval register and give actually their flag to ships is economical. Instead, basically, the naval register of each country, once they were a public organization, now there is still a public authority for each country that is in charge to supervise the activity of registration and the navigation and so on. But actually, the practical activity are many countries given to under concession to private company. So there is for example, in San Marino, there is a naval authority who is in charge formally of to take care of the seagoing vessels that travel under the flag of the Republic of San Marino. And but this authority it's just a supervisor. All the practical activity, so the registration of the ship, the controls in regard to the security, the controls regarding the skills of the crew, the security, and give actual the flag to the ship, and is a private company who work under concession by the government, and its activity is under the supervision of the naval authority. It was enough my explanation. Okay, I think yes. Then I have a question by Julia Yurichenko. Julia is here?
Yes, I'm here.
Okay. You asked me, how does the international law respond to the contemporary challenges such as cybersecurity, human trafficking, and climate change? This is a very difficult question to answer, because you touch some matters that currently very hot, but belongs to different areas. For the human trafficking is something that we will talk about today again, is an international criminal court. There are specific institutions that manage this type of this type of crimes, was specifically recognized by under the authority of this legal entity. Cybersecurity is it's a new word because the cyber world is entering right now in another phase. I remember when around 20 years ago, when the cyber world started to enter in the economy. We at the time discussing about the domain name, how the influence of the location of the server, irregular the taxation of the online sale, all these type of matters. Basically, the cybersecurity is, I can think, is an evolution of the cyber world. In the sense, the first issue they were that were dealt on the international level were the economical issue. Then we started to talk about the cybercrime and, as a consequence, cybersecurity. This is, we can say, is dealt in the same way that any other matters. Let's say, with convention, treaties, a bilateral agreement between states. Like the other crimes or the other way to prevent and solve the crime. Climate change is another topic, because this is a more specific matter that involves the international public law. Also, because it's also part of it involves also the approach of the state, the single state, to this specific matter, to this specific challenge. Because the climate, as a consequence of the climate change, there are several measures that were taken by the organization, the international organization, prevent the damage to the climate. And also there are the problem that this type of position can create a single state. One problem that is well known is the problem in regards to the climate change as a consequence of the carbon emission. There are international decisions taken by international organizations in regards to limit the carbon emission, but there are countries for which is just the climate, the limit on the carbon emission is just the limit to what is the current what is their current development. They already have reached a certain level of development, so they can start to think to approach the problem in a different way. There are, like, say, thinking about the European Union, United States, and there are other countries in which the development of the economic to the modern world is still ongoing. And for this, the climate change and the limitation that they are put to certain, so for example, in this specific case, to the carbon issue, can be severe limitation to their economical growth. It's something that is it's quite complicated to deal with. In some way, if you remember in one of the previous lesson, we speak about the problems that sometimes are created inside the country after the signature of an agreement. Because the entity who was in charge to negotiate the agreement for the state was not well connected inside the state administration to the entity that had to manage the enforcement of this agreement. And this is create this create a lot of problem because to give a very simple approach to the matter, the guys inside the country who have to enforce, they go to the other and say, what in the hell you sign? because this is impossible. This is against our plans for the economic development and so on. I think that the climate change is something like is an internal change, is an internal challenge for the enforcement and the application of the international law. Last question from last two questions from Inga Yeremenko. She asked me, in your opinion, what are the problems of implementing the international law? There are, I think, is another difficult question, because there are plenty of problems that need to be solved, but it's problem that they have always plagued the international law since the beginning of the time, because everything connected with implementing the international law going on the field of the arbitration, of the compromise, and that is the key point and the most difficult point for all the system. As we said many times, there is no central authority to hold to which all the states have to answer. There is no central authority can impose its authority and its rules to the single state, like the central state do for the national state do for their citizen. Everything is based on compromise, and this is and to find the right way to compromise between the different needs of the single state. I think one of the key problem. The second question of Inge is also very interesting. What is the legal personality of the international organization? But I will not answer to that, because there is a specific part of a future lesson, probably in the next lesson about that. And so I don't want to. I don't want to answer, because I don't want to anticipate what will be exposed in a more complete way, let's say in a month or so, or 15 days, I think, because I think the next lesson we should be earlier than the end of the month. I think it would be within the 15th of December, I think. Okay. Going back to our lesson, last time we are speaking about the International Criminal Court, and we didn't finish the matter, because we speak in general about the International Criminal Court, and then we have 6 cases of different positions that different countries take in front of the International Court, that they were very interesting to examine in detail. Interesting because one of them is Ukraine, the second is Russia, the third is United States, and then we have Israel and the Palestinian state that are right now on the international chronicles on the newspaper. So I think is a matter that will be interesting to go in deep, because there is a war also there. Very quickly, speaking about the International Criminal Court, I repeat a bit what I already told you. The International Criminal Court has been established on July 17, 1990. Started the idea to create an international criminal court was born with the Statute of Rome that was adopted during the diplomatic conference in Rome. It takes place at the FAO Palace in Rome. FAO is one of the organization of the United Nations. And the diplomatic conference was in July 1998, and it was the Statute of Rome was ratified in 2002. Why it takes 4 years to ratify the statute after the conference? Because to be there were a lot of countries who signed the Statute of Rome, but there was a process after signing to actually fully adopt the Statute of Rome and recognize the jurisdiction of International Criminal Court. The position were different from a state to another, due also from the political consequence of signing an act that create an international and independent criminal authority, criminal court. It was stated that the Statute of Rome cannot be considered ratified and enforceable until at least 60 countries of among the one who signed the treaty will not have fully implemented the ratification process. And this happened in the number of 6 states was reached in 2002. And this is also an important date, because the International Court started to function and as authority on the crime committed starting in 2002. Exactly, to be very precise, the court can judge the crime starting from what was committed after the 1st of July 2002. Briefly again, some historical notes. The International Criminal Court was preceded by other tribunals, other international courts. The Nuremberg courts, the Tokyo courts that judges the crimes against humanity that were committed after the during the Second World War. In Nuremberg, the crime committed by the Germans, and in Tokyo, the crimes committed by the Japanese that we can say were not less terrible than what committed by the Germans. And of course, about another thing that should be noted, that in regards to this court, there were also of course the right decision, because what was done during the Second World War and during the period before the war, because some of the crime punished by the Nuremberg court started to be committed before the war, just after the Nazi take the power in Germany. So starting from 1933, 1934. And one of the first victims were the Germans themselves. The crimes committed by the Japanese started with the war against China, and were and there were a lot of cruelty and a lot of very hard crimes committed during this war. So they started in 1938. But anyway, there was some, let's say, theoretical issue, because this court represents the first time that the winner of the war were able to judge the losers. And it was a kind of precedent. Another thing that were debatable was that all the Allied powers were represented to the court. So even the Russians, even if the Russian at the beginning of the war, the Soviet Russia take a position that was not completely against the regime that later were on whose representative later were on trial, because and the Soviet Russia committed some kind of crimes or genocide by themselves. You think about the massacre of the officer and the public official, a Polish public official in Katyn. So it's something was debatable. Before that, another historical notes was the fact that there was after the First World War, there was in the Versailles Treaty, there was the request of the winning Allied powers to put on trial the Kaiser, the Imperator, the Emperor of Germany, for war crimes, for started the First World War. But this, with the request, was never implemented because the Kaiser fled to Holland. The Dutch government, who was neutral, don't even think to give him to anyone. And actually, it was a kind of controversial request because, as you know, if you studied the history, the First World War was not started by Germany. It was started by Austria and Serbia, and it became a world conflict for a kind of domino game due to the international alliance treaty across the Europe and across the world. After these two courts, there were other international courts that were created for special events. One for the genocide, the most famous are the genocide of Rwanda of 1994, and the special tribunal for the crime of war committed in committed in the former Yugoslavian state from 1991 to 1999. And actually, this court started to work after the war and finished and closed in 2011 with a sentence issued against Ratko Mladic, the commander, the former Yugoslavian general who commanded the Bosnian Serbian armed force. Briefly regarding the crimes, we have genocide, crimes against humanity, war crimes, crime or crimes in general, a crime of aggression. Talking about these crimes, one of the political problems that were, and we will see later in this lesson, one of the political problems was the definition of this crime. Some of the countries didn't sign or did not ratify the treaty established the International Criminal Court, because they have issue or reserves in regard how define this crime, and also which crime should be included in the jurisdiction of this court. As we said before, it's also like the International Court of Justice. This is kind of arbitration court. So its jurisdiction, again, this is the same problem that we took before. It's the authority of the state. The states have to agree to let their people judge, to be judged by the International Criminal Court. They have to recognize this value. And so their the technical jurisdiction of the court is limited to crimes committed in within the territory of the crimes that sign and ratify the statute. If is limited to the to crime committed by citizen of the state that signed and ratified the statute, and crime this referred to the court persecution, the crime referred to the court persecutor by the United Nations Security Council. And aside from the last case, you see the you say that is the arbitration character of the court is predominant. We say that there was before that there is a path for the country who simply signed the declaration to fully implement the Treaty of Rome and to accept the jurisdiction of the International Criminal Court. First step was, of course, the signature. Then we have ratification of or accession. What is the difference? The phase is the same. What is the difference between ratification and accession? Of course, the treaty was signed by the representative of the state, but the representative of the state, as you know from the constitutional law, do not have, in many cases, the full power to ratify a treaty. So, for example, the President of the United States can sign a treaty as a representative of the state, but the treaty has to be later ratified by the Parliament, the House of Representatives and the Senate. And it's like a bit like in the commercial law. In the commercial law, you have the legal representative of the company that sign a contract, and he can have the power, or he have to be, in some cases, he have to be, usually in the commercial company, it's when a legal representative of a company has the full power to sign. But in some cases, it's happened that he signed it, then he has he asked for an extension of his power or confirmation by the shareholders meeting. It's not something totally uncommon. So at the Convention of Rome, it was at the international meeting in Rome was established this principle. The state will sign, and then the government or the legislative body of each country will ratify the treaty. And this happened. For the countries that didn't sign the Statute of Rome at the time in Rome in 1998, it was established in different parts. They can sign and ratify the Statute of Rome in one single shot, let's say, with the accession. After this, after these two steps, so signature and ratification or acception, another step was the ratification of the single amendments, because since 1998 and 2002, the treaty that established the International Criminal Court was subjected of some amendments, and also this have to be ratified by the signing government. Last step, the approval of the complementary and cooperative national legislation, because even if a government signed the treaty, ratified and it ratified, so it's accepted by the local legislature, ratified the amendments, there is a vacuum of law. If you sign a treaty, this doesn't mean that a international authority can take some of your citizens, bring away to be judged as for any crime. Let's say in the normal way that the criminal law is applied in each country, if a person commit a crime, it has to be judged by the local courts. So there was a need of a complementary cooperative national legislation that allow to transfer the jurisdiction of the crime, of the certain crime, from the national court to the International Criminal Court, and also to transfer the custody of the person accused of this crime from the national authority to the international authority. And also because otherwise everything will be an abuse. These are the complementary and cooperative national legislation. So how this transfer should be made, how this transfer of authority should be made, and this is something quite important. As we said the other time, there are around 130 states that have signed the Rome Statute, but 13 have ratified. So we have just 100 countries that recognize the authority of the International Criminal Court. And plus there are 41 states that never signed, never accepted the statutes. And some of them are, let's say, quite important, because we have China, India, Turkey, Qatar, Saudi Arabia. They are all important players, important regional player, important economical player, important global power like China and India. Why they didn't do that? Because they say they have their own vision, political vision regarding what is a crime, what should be persecuted. And frankly speaking, probably they fear to be themselves persecutor or the member of their public apparatus or their government to be persecuted. Of course, you know that Qatar and Saudi Arabia, they are monarchy, but they are not, of course, they are not Denmark, they are not Holland, they are not Great Britain, that are a constitutional democracy. There is a country where the king actually rules. And this is something that creates a situation that we can be in terms of decision and action. It creates situations that were acceptable and normal in Europe, let's say 200 years ago, not going too much in the past, but not now, not in a modern world. There are also 4 states that revoke signed, signed the treaty, ratified the statutes, but revoke their ratification. We'll talk about them in detail later. Two of them, most important, that are South Africa and Russia. And there are also states that signed, but then openly stated that they don't want to ratify it because they have political issues against the creation of the International Criminal Court. By the way, 2 of them, it's very interesting from a certain point of view, because if you think the major actor of the Nuremberg trials and the Tokyo trials were United States, Russia, then Soviet Union, France, Great Britain, and actually 2 of the countries that were mostly involved in the establishment of this court, United States and Russia, decided not to be part of the International Criminal Court, which is actually, let's say, a descendant of the Nuremberg court and the Tokyo court, a consequence of them, because more than a practical or a technical link, there is a link of principle. Very basic principle. This you cannot allow, no one is allowed to do this. Then there is a different opinion and some fighting what should be identified with this. But it's a principle. It was an established principle that something extremely brutal, extremely cruel were crimes to be punished because they are against not only the victim, but everyone. Another interesting is that one of the, let's say, victim state, not victim state is a bit too much, but one of the state that was created by the descendants of the victims of the crime persecuted in Nuremberg, I'm talking about Israel, is not part of the court. And this is a kind of interesting, more than from a legal point of view, from a sociological point of view. Anyway, we see a 4-step approach. The first state, the four-step approach diminished again a lot of the number of the states that fully implemented the treaty. Just the path to reach to have the Treaty of Rome fully implemented are only 4. So are Croatia, Germany, Netherlands, and Slovakia. I tell you, the full implementation of these parts doesn't mean that the crime committed in the other nation cannot be persecuted by the court. For example, Italy have signed, approved the treaty. Actually, it was one of the countries that pushed for a lot to have the Treaty of Rome signed. But we are far behind in several of the following steps. Anyway, if an Italian commit a crime that can be considered like a genocide, is involved in this type of crime, or the Italian government, for we don't know which kind of madness, actuated a policy that can be considered genocide or other crime, like the forced transfer of people. For example, we have a not a considerable German community in the north of Italy, close to Austria. For example, the Italian government decided to transfer all the to force the transfer of all the German community to Sicily. This will be an international crime. In this case, the court has full authority against Italy, against the member of the Italian government that acted, approved, and executed this order. Actually, I have to be precise. The authority of the International Criminal Court is, we can say, from a general point of view, is against the country, but in the practical way, is people who were the decision maker and the executioner of this crime. So it's a personal responsibility. Of course, there is a moral responsibility against the state, but this is not persecuted. Of course, there is when there is a blame, but the crime itself is persecuted, looking and punishing the individuals who planned and committed the crime. Anyway, going back, if Italy decides to force a forced removal of the German community, German-speaking community, from northern Italy to Sicily, the International Crime Court has the authority to persecute the member of the Italian government who did this. But the key problem is, if they ask to the Italian government, later Italian government, following Italian government, to give the custody of these individuals to the court, or to let's say renounce to the criminal jurisdiction over this gentleman in favor of the court, there is an actual problem in regard to the way how to proceed, because there is a legal vacuum due to the fact that not the transfer of authority, legislation about the transfer of authority, the transfer of the prisoner, and so on, has been fully implemented. And there are a lot of countries that are in this way. Of course, it's a type of conflict that in a way or another, it could be solved. But still, there is a problem. And I want to clarify that this delay in approving all the first step, in my personal opinion, is not voluntary. Is not, there is no bad faith in this. It's simply that in some countries see it as a priority, some other countries no. In general, let's say that we have a good point, reach a good point with many countries, but not with all. Now we look. Yes.
Thank you very much for answering my question. I'm very interested in your perspective as a professional. Thank you.
You're welcome. The international, going to the second part of the International Criminal Court, of the lesson of the International Criminal Court, I speak about 6 cases that are quite interesting of, let's say, of conflict or issues in regards the court itself that prevent the signature or the full application of its jurisdiction. I start with the first case is South Africa. South Africa is interesting because it was a country that it was one of the promoters of the Rome Statute, and also because it's at the time its president was Nelson Mandela, that was a political figure that has all these type of issues close to his heart. But even if the government, after Mandela retirement, if the government is in South Africa is retained through democratic election by his own party, the political situation has changed. Because now South Africa has made several tentatives to stay back from the treaty, to refuse the jurisdiction of the International Criminal Court. This is not for national reason, not for domestic reason, not because they fear to be someone in the South African government fear to be persecuted or to go or to be subjected to the jurisdiction of the International Criminal Court. I say that because we will see with other countries that this is a main issue for other countries. Here, the idea to step back from the treaty, it's born for international politics reason, for foreign politics, for the political position that the country took on the international stage. South Africa signed in 1998 and ratified in November 26, 2000. It has never, South Africa has never ratified the amendment, but it has already issued and approved all the complementary and cooperative national legislation. So the amendments are important, but the practical part of the treaty is all implemented. Technically speaking, the African judicial system can arrest an individual and transfer to the jurisdiction of an international criminal court with no legislation vacuum, committing no abuse. And this is something very, very important. Also connected, we'll see, with the reason for of the government to try to revoke the treaty. In 2016, the South African government notified the withdrawal from the treaty as a consequence of non-execution by the mentioned government of an arrest warrant issued by the International Criminal Court against the Sudanese President al-Bashir. It's connected to what I said before, in the sense that we have a country that is perfectly legitimate to arrest someone and given to the jurisdiction to the court, and they didn't perform. And this is for what? For diplomatic reasons. In 2017, the High Court of South Africa declared the notification of the withdrawal act declared the notification of the withdrawal act that was being notified in 2016 as illegal, and it has to be cancelled. So basically what's happened, the government say we issue an act in which we declare the unilateral withdrawal of our signature. We're not part of the court anymore. And this is a high level. This is showing a high level democracy of the institution of this country, and the court say no. This is not. This is legal according to our law, because all the legislation that was implemented, approved, probably declare the complementary legislation, probably established when the government was allowed to revoke the agreement to the treaty and whatnot, and they say in this case it's not possible. So the withdrawal didn't take effect. In 2023, there was another the South African government try again to revoke the signature and the ratification. In 2023, a withdrawal bill was proposed against in the parliament, this time to allow Putin to take part to the BRICS conference without the risk of being arrested. But again, the withdrawal process was not fully implemented. What's happened is in the same case as before. Before, we have the president of Sudan, who was at risk of arrest. In this case was Putin, because there was a BRICS meeting that was going to take place in South Africa. Of course, let's say we are in two different situations, because the Sudanese president al-Bashir was, let's say, with all respect with the Sudan, was not a notorious man outside the political world. Vladimir Putin is much more famous or infamous, as we want to define him. Therefore, the lack of enforcement of the Statute of Rome, the lack of enforcement of the arrest warrant against Putin was not something that will go unnoticed in case Putin will go to, we should should have traveled to South Africa. So the South African government try another way, because a action previously in this is constitutional law, previously in 2016, an act issued by the government, direct action from the government, was declared illegal by the constitution, by the High Court, the Constitutional Court of South Africa. In 2023, the government tried another way, the parliamentary way, tried to pass a bill to revoke the ratification of the treaty, the signature ratification of the treaty. But again, in this case, was the parliament who doesn't find the proper agreement among its members to approve this bill. So we are in a situation in which right now the South African government considers himself out of the court. The court considered to have still jurisdiction over South Africa and South African individuals, and still consider South Africa bound to enforce the warrant, the arrest warrant, or any other order issued by the court. Another interesting case is the Palestinian National Authority. This, I can see, is a case that is the opposite of all the other, because here we have a legal entity, very special. We will talk a little later today when we speak about the state as an object of the international object and subject of international law. We have already 2 months speaking about states. Second part of the lesson today is to explain what is a state. So we have to create a definition of the state. In this case, we have an entity which is considered a state, who try to present itself like a state, who want instead to be part of the court, to have a full recognition to the court, also because it means a full recognition as a state. So the Palestinian National Authority had submitted 3 requests before being accepted as a country member of the treaty and to be submitted to the authority of the court. And it's a kind of funny, because they try in any way to be member of the court. And it was, and the problem that they have, they were, they can say from a certain point of view, formal problems. But this is also something that is very important, I think, for law students, because one thing we have to understand that in law, the formality is also substance. Procedure is also important, like the legal procedure are important as much like the law. The first request by the Palestinian National Authority was submitted in 2009, but it was rejected because the Palestinian National Authority was not considered a sovereign state by the public prosecutor of the International Crime Court. Second request was submitted in 2013 after that the position of the public prosecutor is connected with what we will see later about the qualification of the Palestinian National Authority as a state. according the international law system. A second request was submitted in 2013 after the General Assembly of the United Nations passed a resolution admitting the Palestinian National Authority as an observing member in 2012. Again, in this case, okay, the public prosecutors say, I'm sorry, guys, you cannot join the court because according to my judgment as a man of law, you are not considered a state. Your government cannot be considered a state. Your nation cannot be considered a state as according to the international law rules. And then there was a new fact because the Palestinian International Authority was admitted as at least as a observing member to the General Assembly of the United Nations. So this gives the open for a new request. But this second request was again rejected because it was submitted by the Palestinian Minister of Justice and not by the head of the government or by the Ministry of Foreign Affairs. So the problem is, again, formality. And again, and in this case, it was an internal problem created by the internal problem created inside the Palestinian government. A third request had to be submitted in 2015, and this finally was accepted. Despite this, the problem is not totally solved because some countries still refuse to recognize the authority of ICC toward the Palestinian National Authority because they do not recognize the latter as a sovereign state. So, because this is we are in the system of we have in a system of arbitration. So I not only want to be part of the court, I have to be accepted by the other. They recognize me the dignity. Because in this case, the situation is a kind of, let's say, it's a tricky situation. In the sense that if you are for the type of jurisdiction established in regards to the International Criminal Court, you can be judged by the court, but to be under the authority of the court means also that a crime committed in your territory is under the jurisdiction of the International Court. So other people who are submitted to the authority of the court can be judged for crime committed in your country. What was the purpose? It's political. The Palestinian National Authority wants badly that the Israel government, a member of the Israel government, will be judged eventually by the International Criminal Court for act that the Israeli government committed in the occupied territory like Cisjordan or Transjordan or Gaza. So there is a mix of law, jurisdiction, and politics, all linked together. At this point, we talk about Israel. Israeli original vote against the Treaty of Rome at the Rome Diplomatic Conference in 1998, but later signed it in 2000. So this is very interesting because, as I say, Israel doesn't want to be part of the court. Later they find, but in 2002, Israel officially announced that he has no intention to ratify it. Probably that was connected also with the issues or with what we were just talk about in regards to the Palestinian national authorities, or other things that happen in the Middle East, because it's a country that is always in the status of war. It's not something something that happened in 7 March. 7 October 7 is something that is a promptly explosion of the fighting and the brutal explosion of fighting, but the status of war was always present. Why in 2002 Israel officially announced that they don't want to ratify the treaty. The reason behind this decision are connected to the nature of the crimes that the court should deal with. Israel laments the missing inclusion of crimes like terrorism, drug traffic, while contesting the inclusion of other crimes like forced relocation of civilians within an occupied territory. This is actually one problem, because Israel is victim of terrorism. He has been always, but he also applied some, let's say, some policy that can be considered like a crime by the International Criminal Court. For example, we have a case in which we have currently we have a warrant arrest against Putin for forced relocation in regards to the abduction and transfer of the Ukrainian children to Russia. If we see the situation from a certain point of view, even some relocation that relocation policy Israel applied in some areas of the occupied territory can be at least examined as a crime by the International Criminal Court. Examined doesn't mean that there are crimes, and there's different different situation, but is a situation that could be instrumentally interpreted by third parties or one of the party involved. Another issues is for Israel is the composition of the court. The judges are appointed according to the United Nations regional groups of state, and Israel fears to be underrepresented within the court due to the fact that she doesn't belong to any regional groups. Because Israel is in the Middle East, the countries that belongs to this group are Arabs, Muslim, and until yesterday they were mortal enemy of Israel. So it was with them. Israel don't belong to this group, and for them to say, "Oh, I cannot elect one of my judges in the court." This is a technical issue, but is present. It can be solved transferring Israel to the European group, but let's say this is a matter of politics. Another critics that is the powers of public prosecutor that Israel considered too broad. So this is something that is another important issue. Ukraine never signed the treaty, and there was a ruling of the Constitutional Court in 2001 that states its incompatibility with the Ukrainian Constitution. So in Ukraine doesn't lack the desire or the will to be part of the treaty. It was a technical problem. From 2006 to 2012, Ukraine took some preliminary steps to join the treaty, including the planning of an amendment of the Constitution. The ratification of the treaty was necessary because it was a precondition imposed by the Ukrainian-European Association Agreement signed in 2014. So in this case, there is the will and there is also necessity because it's something imposed by the Treaty of 2014. So there was some step. In 2016, the constitutional amendments necessary for ratification of the treaty were approved, and the Zelensky administration in 2019 declared the ratification of the mentioned treaty as a priority. So there was finally everything was okay from the constitutional point of view, and there was a full will of the current government of Ukraine to ratify the treaty. Unfortunately, there was the Russian invasion that postponed the ratification until the end of the war. Ukraine, but has also a very particular position because there is a possibility to have an extension of the international jurisdiction even to a country, even if a country is not part of this of the treaty. If it will not be so, there will not be the possibility to issue a warrant, an arrest warrant against Putin for what he did during the occupation of Kherson area and the current occupation of southern Ukraine. So there is a possibility for countries to say, I'm not a part of the treaty, but I want that the treaty have jurisdiction, a court have jurisdiction over my territory. This acceptance of the jurisdiction is limited by time frames. These time frames are quite important. They are connected with the ratification of 2002. As we see, the treaty it's valid for the crime committed after July 1st, 2002. We are in the same case. I'm a country. I'm not part of for my reason. I'm not part of the treaty yet. I want to accept the jurisdiction. I will give a time frame in which all the crime committed are going to under the jurisdiction of the court. In regard to acceptance, the International Criminal Court jurisdiction declared its acceptance for the first time in April 2014 in regard to the fact happened from November 21, 2013 to February 22, 2014. Basically, it's the Maidan period. Ukraine specifically accepted the jurisdiction for the period and for the event that happened during the Maidan revolt. A second declaration of acceptance was issued in September 2015 in regard to the facts that happened after February 20, 2014 until now. Basically, it's based on this acceptance that Vladimir Putin received a warrant from the International Criminal Court, an arrest warrant from the International Criminal Court for forced transfer and abduction of Ukrainian citizen, in the specific, the children, sorry. Case 5, Russia. We're talking about Ukraine, now we have to talk about Russia. Russia have a kind of very plain policy towards the International Criminal Court jurisdiction. Russia signed the treaty in 2006, and it was part of the court until 2016. In 2016, the International Criminal Court published a report about the Russian military activity in eastern Ukraine. The report didn't state anything particularly relevant for anyone who was aware of the international political situation. It simply made clear and affirmed that there was an ongoing state of war in eastern Ukraine between the latter and Russia. And there was also an ongoing Russian military occupation of Crimea. Basically, nothing that anyone didn't know. As a consequence, Russia sent a note to the ICC, to the International Crime Court, revoking the signature of the treaty. So basically, Russia get under the spotlights for what was happening in Ukraine for the occupation of Crimea, but it was not something that they say that it's we can say there was we touch Russia in their majesty and say no, we don't want to have anything to do with you, because it was clearly registered just a state of war. Case 6. Case 6 is United States of America. This is a very peculiar case because the approach to, when you think about United States, that one, the greatest democracy of the world, the first one, you have to think that they have an approach, a very open approach to the International Criminal Court. Also because they were the promoter of the Nuremberg trial, the Tokyo trial, and so on, and they were also supporter or any other action taken to punish the crime committed during the Balkan War, in Rwanda, and so on. Instead, it's a surprise maybe for many, United States take a distant position from the International Criminal Court. The United States approach to the International Criminal Court has been always skeptical, with an attitude from the single presidential administrations that range from no cooperation to open hostility. This attitude is caused by the difference of the American people toward the foreign legal system that are considered unfair and unreliable, even if a foreign court belongs to a democratic and reliable country. As a consequence of this diffidence, there is an extreme strong tendency to shield the American subject, both human persons and legal entities, from the jurisdiction of other countries. This tendency is particularly strong if the American subjects involved are members of United States Armed Force or belonging to branches of United States government. I tell you, there is a general skepticism from the people from the United States because it's an attitude that Americans have. I don't think speak bad about that. I know very well, I love them, but they consider a bit themselves the center of the world. And coming to judiciary system, they strongly criticized the other the other judiciary system. Also, normal criminal case, we don't need to speak about international crimes. There are some cases that are quite famous in Italy. One is the case of Meredith Kelcher, who was a British subject. She was a student in Italy. She was killed by a roommate, the fiancé of his roommate, other people during a Halloween party for, let's say, was a kind with erotic games that go bad. One of the case was one of the people accused and later received a sentence for that. It was an American girl, whose name was Amanda Knox. And this case was just something not particularly gruesome, was a normal murder case. Amanda Knox was judged and condemned in Italy, and there was an explosion of the public opinion in the United States that was outrage because this girl was innocent, because Italian justice doesn't work, because they don't have they don't have any right to judge her, and so on. Simply because she was condemned by a court that was not American. Amanda Knox later was able, during a trial, during a second-degree trial, and the High Court appeal was able to go to United States, to escape to the United States. She was condemned. I think she's been condemned to 25 years, but she's now free in the United States because the United States did not give don't give any extradition for their citizen, even if it was Italy is an allied country. We have a very good relation with them. We have a democratic country, but nevertheless, if an American is condemned abroad, they don't give you back. They have the tendency to shield the members of the armed force, and we have another case in Italy. It was the Cermis incident. The Cermis incident it happened in early 2000. What's happened in this case? Two American jets were flying too low. They were flying in a way that was against the flying rules for military jet. They were forbidden to do that by the Italian authority. One of the jet cut the cable of the mobile transfer for skiers, for people that were going to skiing. The vehicle in which they were traveling fall from a mountain, and there were 60 people were killed. We asked immediately. The pilot was transferred to the United States within a week. The Italian, of course, it was an incident, was not something voluntary. But in any case, there were 60 people dead for an action that was for an action committed by a military pilot who broke the flying rules. So, of course, it was not a voluntary homicide, it was involuntary homicide, but there was a responsibility. Not only a criminal, but also a reparation that have to be paid. The American transferred this pilot immediately to the United States. There he was, he went on the military trial. The military trial was very, he was condemned to, I think, a small time in detention. That is not fully, he was not fully served in the military prison. I think he got 2 years or something, and he at the end stay in this prison for 1 year and 8 months or something. This officer was not stripped of, he was not expelled from the Air Force, and he was not stripped of the rank. And the Italian justice was taken a distance. This is something that this tendency is because started because during the Cold War time, of course, there was a confrontation between the Soviet bloc and the NATO. The American agency, the military, were used to make undercover operation, and they still do today. In some way, they were this type of operation where take place, of course, in the interest of the alliance and the common defense, but nevertheless they break the national rules. We have a case during the war on terrorism in which an imam who was working Italian resident, was, I think, he was from North Africa or someone, but he was the imam of a mosque in Milan, was abducted by the American Civil Secret Service and taken to Guantanamo in Cuba, in the military prison, breaking all the international rules regard arrest warrant and so on. The Americans have this bad tendency to break the rules and try to do whatever they want. Not, they can say, not with bad intention, because, but they consider themselves superior to the local law. Another note, you know that in Iran there is an Islamic regime. The Islamic regime came after the Shah regime. The Shah regime was a king of Persia. There was a revolt who sent away the Shah and established first a republic, then an Islamic republic. There was several reasons why the people were discontent of the regime of the Shah, but the last drop that made the country explode was a law approved by the Iranian government, pushed by the United States government, that guarantee the full immunity to the American personnel in Iran against any crime. Basically, according to this law, an American soldier or officer could kill an Iranian and not be persecuted in any way by the local justice. Anyway, going back to the treaty, the US government signed the Treaty of Rome, But the US president at the time, Bill Clinton, never submitted it to the parliament for this ratification. He openly discouraged its approval. It's very strange because not strange, but unusual, thinking that one of the most democratic and open president that the United States has, Bill Clinton, very famous, very good president, let's say, didn't he sign, but he tell clearly, I discourage any of my successor to submit for this treaty to the parliament, and I will not, for sure, I will not do it. Then after Clinton, there was a Bush administration, after Democrats, Republican. Under the administration of its successor, George W. Bush Jr., Congress approved the American Service Member Protection Act, ASPR. So what is this act? It's an act that goes in the opposite direction of the International Criminal Court. According to this act, the United States government is inhibited from giving any support to the International Criminal Court, including funds. The ASPA urged also the US government to enter into bilateral agreements with the signatory state of the treaty to shield the American subject on their territory, which could be eventually persecuted by the International Criminal Court warrant orders. Luckily, only the few signatory states of the treaty accepted to sign these bilateral agreements. In Europe, only Bosnia, Albania, North Macedonia, and Romania. We're going in the opposite direction. They make a law given first by the parliament. First, we don't give any funds to this association. And you consider the United States are one of the most, one of the countries who give most of the fund to the United Nations. But with this, they don't want to have anything. Then, in the law, is written that the government has to sign agreements with the country who make the agreements, we sign the treaty, for this application of the treaty and to shield their personnel. This was the same reason because the Americans, it's debatable. It's, of course, if it's good or bad, they do cover operation, both military and secret operation in several countries for common protection. That is, but breaking the law of the single countries, both of the local nation, of the local law of the nations, and also creating a situation that can go under the interest of the International Criminal Court. The ASPA contains also the authorization of the president to use any means to free American subjects from the custody of the International Criminal Court. Other step, by this law, the president, if someone, an American subject, is under detention of the International Criminal Law, the president of the United States has the right to send the Marines to free him. It's tough. It's something really, really tough. The ASPA also contains the prohibition for the American government to provide any military assistance or cooperation with the state that has ratified the treaty. This measure don't discourage the other country from accepting the jurisdiction of ICC, had practically little or no effect. The US government was forced to introduce a list of exceptions to this provision in regard to the NATO member state and other strategic allied states. What they say, okay, first, no funds. Second, we want to have bilateral agreement to shield our personnel. Measure that doesn't work much. Third, I'll send the Marines to free someone who is under the jurisdiction and the detention. Fourth, okay, we don't give any more military assistance to any country who is who is signed the treaty. This was the purpose to push the other country. First, I say, you sign, I try to get guarantee for myself and my personnel. Doesn't work. Next step, I discourage you to sign. The big problem is that also this measure doesn't work because most of all the NATO members, Italy, Great Britain, France, Germany, Norway, Denmark, Spain, Portugal, and so on, signed the treaty. So the America has to step back and sign, let's say, amendments to the law, say, okay, with Italy, we keep on with the military cooperation with Britain, because otherwise, there was no possibility to have military cooperation with anyone, sign it. But you see how the United States administration tried to push for against the international criminal law. This was the Bush administration. Then came the Obama administration. The Obama administration was less openly hostile to the treaty, but still not ratified, and made it clear that there was no intention to do it. So we can say that there was the same attitude of Clinton. Actually, there was a political string that bound the Clinton administration with the Obama administration. Then we have Trump. Trump administration was also open hostile to issuing hostile at the point that issued sanction against the International Criminal Court members due to some investigation on the US armed force personnel in regards to alleged violation of human rights in Afghanistan. Note regarding American politics, you see that there was the Democratic administration were, let's say, uncooperative. The Republican administration were strongly against. They tried to challenge in any way the International Criminal Court. In this case, Trump, the problem for Trump was the fact that there was some investigation of the International Criminal Court in regards the attitude and some alleged violation of committed by the American force in Afghanistan. The hostility of Trump were showed refusing the visa and revoking the visa to the public prosecutor of the International Criminal Court and to some judges of the court. He didn't much more than that, because we can say all the rest was done previously by the Bush administration and it doesn't work. I have to make another clarification. Why the Republican administration is more strong against the International Criminal Court? because traditionally in American politics, the Democratic are more open and they are for intervention on the global scale. The Republican are in foreign politics for the isolation of the country. They want to reduce the international bonds and obligation of their government as much as possible. Traditionally, the Democratic started the war, the Republican ended them. It's happened in Afghanistan, it's happened in Vietnam, and so on. The diffidence against international institution and against foreign legal institution is strongly connected with the idea of international politics of the Republican administration. Last, we have the Biden administration. The Biden administration lifted the sanction, but remained critical on the matter of jurisdiction of the International Criminal Court on the US Armed Forces personnel. Biden canceled the revocation of the visa and the ban of the judges of the International Criminal Court issued by Trump, but he agreed and was pleased by the arrest warrant issued against Putin and other members of his government. But the matter of the jurisdiction over the United States Armed Forces personnel is still something hot. Also because, and it's happened that we say we have the case in Iraq of the Abu Ghraib prison. We can say that United States American Armed Forces are not so immune from the violation of the human right. I think it's 4 is sorry, for you is 3. I think we have reached the time, and it's 5 for you. I will close the lesson here. We have complete the first module of the course. I thank you for the attention, and as always, I'm available for any question you could have to submit to me. Thank you.
Mr. Fabrizio, I want to say thank you on behalf of our students. We are very grateful that you once again give us an interesting lecture. So thank you so much and see you soon.
See you. Thank you. My pleasure to be here.